Good evening, everybody. Can everybody hear me?
We can.
Great. Welcome to the first of Westgate Chambers Tea Time Training for 2025. Thank you all for joining this evening. Just some housekeeping before we get started. Firstly, to let you know that this is being recorded. So if there are any issues to do with privacy, please let the clerks know. Secondly, the slides will be sent to you together with Judge Talbot's handout, so no need to take notes. And thirdly, if you could save questions until after, I'll do my very best to answer them, but we don't have the chat function on. So without further ado, the idea for this training came about because I happened to be at court on the 27th of January, instructed in a case. And January 27th, of course, was rollout day for the transparency pilot to go national. And we were notified that, in fact, a reporter was going to be attending our hearing. I thought it would be useful to share with you my experience of having that and the practicalities and how it all played out in court. But before I do that, I thought it might be useful to revisit how we got there, because it's really a seismic change in the way we were used to working in terms of more or less complete confidentiality in Children Act proceedings, as opposed to criminal courts and other courts where it is very common for journalists to be open, and where courts have always been public. So just to go do a little bit of a canter back. The open justice is, of course, a core tenet of our justice system. Justice not only has to be done, but has to be seen to be done. And in the family courts, it's been an evolutionary process. And it was interesting. And when I started looking into this, of course, what's timely is and I forgive my camera, it zooms in and out. It's a bit weird. I apologize for that if it's freaky. The case, you will probably all be aware of the case of Tickle and Another, which was the Court of Appeal case dismissing or reversing the decision of Mr. Justice Williams, anonymizing the historic judges in the Sarah Sharif case. It's a fascinating judgment. If you haven't read it, I highly recommend it. It is short. But one of the things that the Master of the Rolls does is go through a bit of a potted history as to open justice in the family courts. And it's been around for a while, that concept feeding through the family courts. And there's been an acknowledgement that in family proceedings, they are a bit different because of the very private and sometimes salacious content of them. And Scott, going back to 1913, was a nullity proceedings, weren't Children Act proceedings. But in that case, the Lords touched upon how sensitive information is it isn't a reason to prevent transparency and open justice. And one of the Lords, Lord Shaw of Dumferlane, said this: he described publicity in the administration of justice as one of the surest guarantees of our liberties. A violation of the principle of open justice would be an attack on the very foundations of public and private security. So really sort of going back and instilling that this is a key tenet, regardless of the type of case that we're dealing with. Of course, the difference in Children Act proceedings has been the importance of maintaining the confidentiality for children and ensuring their safety and security. But the courts have always retained a jurisdiction to consider disclosure and publication when it considered to be in the interest of justice and the children to do so. And there has always been a balancing exercise as to that process. That took on a statutory footing once the Human Rights Act came into force, when the courts would and had to balance Article 6 and Article 8 and Article 10 in terms of where there were applications, and they were few and far between in those days, but there was always that jurisdiction to do so. And that's set out and mentioned by Justice Munby, as he was then, in the case of Re B. And he set out, that was in 2004. And at that point, there was this growing, and particularly with the Human Rights Act, there was a growing head of steam toward opening justice. And the Labor government at that time had that on the agenda, but expanding open justice into the family courts. And in fact, it was in a white paper that was the Jack Straw, who was justice minister at the time, had a three-phase plan that was going to end with a statutory primary legislation to remove the restraint or relax the restraint on the restriction of publication of information in Children Act proceedings, because of course it was the Administration of Justice Act, Section 12, which made it a contempt of court to publish information from Children Act proceedings. And that's where that ban comes from. But there was the jurisdiction to relax it in certain circumstances, but that's what really restrained publication. So looking at moving on from that presumption against publication and opening justice, that's where it really started in the early 2000s, getting ahead of steam. And the first phase of Straw's plan was to change the rules, the family procedure rules, to allow journalists to attend. So they could attend, but they could not report on what they saw and what they heard in court. And the first change came in 2009 with allowing accredited journalists to attend the family court. The other two phases were not carried through by the government, but at that point there was more and more of an interest in changing the rules and in allowing for more open reporting, and that the Transparency Project, which you may be familiar with by now, and has been really sort of driving this open justice. They were founded in 2015 by lawyers, legal bloggers, academics who had this as their mission. And their stated aim was to make the workings of the family courts more visible and more understandable. At the time, one of the things that was happening, and Re B is a really interesting case. At that time, there were a number of miscarriages of justice. There were a number of headline cases where what was happening in the family courts was demanding a higher level of scrutiny. And so it was looking at that as to what was happening in family courts, rather than we had the end result of what was happening in court, but not an understanding of how we got to that result. And so it was toward that end that the open transparency is aimed. Legal bloggers were a thing that developed at that time, and they're lawyers not connected with the case, obviously, who are not journalists, but who are blogging, reporting on cases or who attend cases in court. And so specific provision for legal bloggers was made. That was the next change to be made in 2018 in the family procedure rules, made specific provision for them. And that really came from the Transparency Project movement. And because of what was happening publicly with these high-profile cases, with miscarriages of justice, with a lot of serious case review cases, the need for media scrutiny of what was happening in the family justice system grew exponentially. And going back a little bit to 2016, another case that's mentioned in Tickle and Another is C, in which the then Master of the Rolls, Lord Dyson, referring to another case, said this: the judge, Poffley J., rightly recognized in paragraph 10 of her of her judgment that open justice is at the heart of our system of justice and vital to the rule of law. As she said, it promotes the rule of law by letting in the light and allowing the public to scrutinize the workings of the law. There is a particular need for the media to act as a public watchdog in care proceedings in the family court because of the intrusion or potential intrusion into the lives of those concerned and what could be a serious interference by the state of family life. And I'm doing a bit of a deep dive into the law here, A, because I kind of geeked out on it, but B, because it's important when we think it's really quite jarring to think about reporters being in court. We're not used to it. And so it's interesting to think about how and why it is so important for there to be transparency in the family court, given the significance of the decisions that are made in these courts. And that was really the issue that Lord Justice McFarlane grappled with when he took over as president. And he really took this head of steam and just drove it. He picked up the nettle with this because what had happened in previous attempts to open the courts was that there was this tension between confidence in the public court system and confidentiality of children in particular and parties involved in these highly sensitive cases. And no one seemed to be able to deal with that and square that circle. And so he took it on and he said, right, this is not too hard. We're dealing with this. And it was in this document, Confidence and Confidentiality, Transparency in the Family Courts, that he set out his vision for how this should happen and the phased rollout of the pilot, the reporting pilot scheme, which then kicked off. And so what then happened was the reporting pilot scheme. And so who was to be reporting, who was this directed at journalists and legal bloggers, as had already been provided for by the family procedure rules. And what? And this is where the sea change comes, because there was a practice direction which allowed for the pilot to happen. And what that did was to change, to relax the restraints imposed by the Administration of Justice Act, Section 12. And so now, for the first time, there was on statute the ability to, or in law, the ability to report for reporters, bloggers, those accredited, on what they heard and saw in court, what Lord Justice McFarlane calls the transparency principle, subject to anonymization, the anonymity principle. Of course, Section 97 of the Children Act is still in play, and that deals directly with ensuring that any information that could identify a child is not to be published. So that is still very much the force. And so the anonymity provisions, and we'll come to those and go into those a little bit more later on. But that's how those tensions are now balanced, and those are the two issues to be dealt with. So what cases are included in the pilot, the public and private law, Children Act proceedings, applications for placement orders within care proceedings, but only up to the placement order being made. It doesn't extend to the actual adoption applications and applications that follow. It does apply to inherent jurisdiction and deprivation of liberty. What's excluded? Financial remedy orders or financial remedy cases. There's separate provision for that, and I'll deal with that at the end. Applications on the Family Law Act 1996. And there were some other cases mentioned in Rule 27, Section 11, in the Court of Appeal. But of course, now there is some cases, in fact, are streamed live from the Court of Appeal. But notwithstanding the relaxation of the restraint on the presumption against reporting, the court maintained and must maintain the ability to weigh the competing considerations and ensure that if a transparency order is made, it is still within the best interest of the children. No one's going to be significantly impacted. And so continuing to consider and weigh up Article 6, Article 8, Article 10. And there are particular cases which will call for either non-reporting, restriction, or delay. And I'm sure we all know, but they are, just by way of example, matters that are subject to ongoing criminal investigation, where reporting of what has happened in family court could prejudice an active investigation. Applications made without notice, where publication of what was said and heard in court would would prejudice the applicant of that application. Where it's difficult, particularly difficult, to achieve anonymity of the child. And we'll come back to that. But that was an important one. Jigsaw identification, where jigsaw identification it's just not possible to eliminate that. And then protected parties where the official solicitor is involved. And then in FDAC cases, hearings like non-lawyer reviews. So those are cases where you're less likely to find a transparency order being made, or there will be restrictions, could be restrictions or delay in reporting. So the phased rollout started on the 30th of January 2023, and it was limited initially to Leeds, Cardiff, and Carlisle, and that was intentional to have 3 very different areas involved, including a rural area, so that there was those who were assessing it and evaluating it could see if there were different impacts in different parts of the country in different places. On the 29th of January 2024, it was expanded to private law, to include private law. Initially, it was only public law proceedings. It was expanded to private law, and also the number of pilot areas were expanded to a total of 19. The process as it was going on was then evaluated, and Lord Justice McFarland, rather, published reporting pilot guidance. And I've hyperlinked a lot of stuff in the slides that you'll be getting, and it's interesting because it sets out the framework for really the system that we will now be working in, and it's a really helpful document, easy to read. So the 4th of November, the pilot was extended, public and private law children proceedings to the magistrate's court. And then roll on the 27th of January, which was National Rollout Day. And so it was extended, the pilot was extended, and whether we can still call it a pilot or not is debatable, but it was extended to public law proceedings in all of the courts in England and Wales. And in order to do that, what then happened was a significant rule change. And that was in section, and I've got them there. But what it does, and effectively in both the Children Act proceedings and placement order proceedings, is that it grants permission to communicate information, to publish information in family court, in Children Act proceedings. And then there are further amendments made to the provisions regarding reporters. So section Practice Direction 27B deals specifically with reporters attending court. So that is now, that's now embedded in the regular family procedure rules. So one of the things that they did in the rollout, which hasn't yet come out here, but in order to assist journalists in identifying what cases what cases are being heard and what might be interesting for them to see, because you won't know if you just look at the court served cause list. No names, a child, no idea of what type of case it is. So hard to identify what might be in the public interest to report. So they came up with a listing system where they listing codes in the case category, which in the pilot phase, there were still hearings that were within the reporters were entitled to attend, but not report because it wasn't in the pilot. And then so it identified the hearings they couldn't attend, that they could attend but not report, and then the hearings that they could attend and report at. So there was the case category and then the issues and the allegations. So that would give them an idea of what the case was about. So if we look at an example from Leeds, and this is from today, so we see the category It's a Category C case, so they can see it, they can attend and report on it. And it's if we go back 1, 2, and 4, so it's a case with alleged neglect, physical harm, and emotional harm. And so that will tell, and that's just the daily cause list, will tell the journalists what the case is about, whether they feel that that's something they want to cover. So then what this comes down to, and what it's all about, is the transparency order, which is what is needed in order for the journalist to be able to report. And this is an order that remains in place until any child to whom the proceedings relate turns 18. It can restrict, delay or restrict reporting, as we talked about, for example, in the lead up to a criminal trial. And in addition to the transparency order, and we'll go into that in a little bit more detail in the next couple of slides, but in addition to the transparency order itself, what the guidance suggests is that the case management order should record on the face of it, if a journalist does attend, their name and contact details. And also, if a judge makes a decision that a reporter should not attend or not report all or part of the hearing, that too should be included on the case management order. So what cannot be reported without express permission of the court? Well, it's standard stuff that you would imagine, because the majority of it is aimed at preventing the identification of the child. So the name and date of birth of the child, the parent, any name that might lead to the identification of the child, any address of the child or the family member or the foster care, school or hospital, medical personnel who are treating, and there's an important distinction which we'll come to, any treating clinicians can't be named, any photographs, obviously, and then this in particular, if it is a case involving sexual abuse, the detail of the abuse cannot be reported. And then, of course, the catch-all, any other information that is likely to identify the child as the subject of proceedings or a former subject child. So who can be named in the reporting? Well, the local authority or authorities, the director and assistant director of children's services, but no other person from the local authority. So not the social worker without express permission of the court. Similarly, CAF-CAS, but not the name of the guardian or the reporting officer without express permission. The independent social workers, if they are appointed under Part 25, but if they are local authority, if they're there to take the place of a social worker for the local authority, then no. Any NHS trust, court-appointed expert, but again, not clinicians, not treating clinicians or other professionals. Legal representatives and judges, and anyone else named in a public judgment. So, what documents can reporters and bloggers see? So, on request, the reporters are entitled to be provided with copies of, and quote from, the documents by the advocates or the parties, if they're litigants in person, case outlines, skeleton arguments, summaries and position statements, thresholds and chronologies. So what you'll notice there is not any other documents have to be expressly agreed to by the court. So what is not expected is the disclosure of any assessments of the parents, for example, psychological assessments, psychiatric assessments, cognitive assessments, any of that is not the norm that would be expected to be provided. So when does this happen? At the start of proceeding. It's the idea is you provide the reporter with an outline at the beginning of the hearing so that they can follow along. And how do we do this? By way of secure email. The reporter must have a secure email address so the documents can be sent to them. So how you prepare. Now, some of you may well have gone to the Family Justice Board meeting in November. and heard the excellent presentation by His Honor Judge Talbot, very engaging, and he provided us with a fantastic crib sheet, which he's given me permission to distribute to you, and it is really your go-to. It's got hyperlinks to everything you need, and it's fantastic. So I'm kind of cheating a bit by copying from him, but I'm just spreading the word. But it's an invaluable document. But the other thing to look at is that the Transparency Project has themselves provided a useful go-to of what to do if a reporter attends my hearing. And that, again, sort of sets you up. And then there's a leaflet that's been provided by the court service for parents and family members. And there's a transparency order template. I couldn't find a link to that, but it's in Judge Talbot's crib sheet. So that will come to you, and that does link in. So you'll have that. And then thinking about jigsaw identification. But I just want to go back for a moment to well, I'll deal with the thinking about jigsaw identification. Oh, that's what I was going to say. Even it may well be that it's going to be a long time before anybody, if I don't know if anybody else has had the experience of a reporter coming to court since the 27th of January, but certainly I haven't. So I don't know how frequently they're going to take advantage of the new rules in our area, but it's good, not that we have time, but if you can do, I strongly encourage you to just have a look at and familiarize yourself with, at the very least, Judge Talbot's cheat sheet, I call it. So you have stuff ready to go. You have an idea of what's being, what to expect. And hopefully talking you through this will give you a little bit of assistance as well, and sort of take some of the anxiety away, because it is such a new, it's a new framework to work from. But the one thing to think about in advance when you have a case is to think about, is there something really unique about this family's circumstances or the family situation, whether it be an issue that happened with the family, their ethnicity, something really unusual about this family that would mean that it's really impossible to anonymize this family and this child. So that's something to really keep an eye out for. So what did happen on the 27th of January? Well, we were happily notified in advance. That's what's supposed to happen. The reporter who was from AP contacted the judge and let her know that she wished to attend. The judge then let us know. What's in an ideal world, what happens is the reporter notifies the court well enough in advance that it can be discussed at the advocates meeting, so that all the advocates are ready and prepared and had time to sort of reflect to see if there are any concerns and any issues, and raise it in good time with their clients. But as we know, that rarely happens, and it didn't happen in this. We didn't know enough in time to discuss it at the advocates meeting. But what did happen was I was not representing the local authority on that occasion, but the local authority barrister did draft the order. It usually falls to them to do it, and circulated it to the rest of us. We agreed that on the basis of what we knew and the circumstances of the case. That was then sent to the judge, who approved it, and then that gets sent to the journalist via the secure email route. And then she acknowledged receipt of it. She acknowledged the terms of it, so that upon her doing that and responding to it, she was then sent the case summary, the local authority case summary. That's all that was given to her on that occasion. So it was all, I mean, to be honest with you, it was fairly straightforward. She was perfectly pleasant. We all shook hands. But it was really super helpful to have that in advance, particularly because of what happened the next day. notwithstanding the pre-planning. Um, on that day, my client was a very young mother who was very vulnerable and neurodiverse. And she was really struggling getting to court. And so she was late. And the court was absolutely heaving. It was in Worthing. And so both criminal and family and civil courts were going at full pelt. And so my client walked in, uh, freaked out by how many people were there generally. And once I had um, let her know that they all weren't there for her, it was just this is normal court business. And then, of course, there were no rooms. So I had to take this young woman back to the most private place I could find, which was in a behind a stairwell, and explain to her as gently as I could that whilst all of these thousands of people weren't there for her case, there was going to be a reporter in court. And notwithstanding the fact I tried to do that as gently as I could, she was really worried, and she did freak out a little bit, and said that. But her concern, and perfectly understandably, was she had this vision of cameras in court, reporters in court. And so once I explained that no, it's a journalist who will be there, who won't say anything, there are no cameras, it's not recorded, and then went through with her what could and could not be reported, and that the judge controlled the information that would be shared and reported, and that every care was taken so as not to identify the children and her. She was calmer. So, so that was really tricky. And so the advantage of it was particularly advantageous to have the knowledge of a reporter's presence um, before the night before, so I think about how to approach my client with this. The other challenge that arose after the hearing was this, and it didn't impact the hearing, but the reporter said to the barrister, the local authority barrister after court, um, it was a non-accidental injury case, and she said, so after this judge decides that the matters in this case, whether the child was injured by the parents or not, does she then refer it to the Crown Court? And we thought, oh, crikey, there's some education that needs to be done here. And what's worrying about that is the extent to which a lack, and it's not her fault, it's that she hasn't had the training uh, and the background given to her about fundamentals of how the family court system works and the Crown Court system works, the criminal justice system works. And what's worrying is how they are going to be able to report accurately and sensibly when they don't understand the system. So there may be a training need in there. I think the Transparency Project is trying to do some work around there, but that was the one thing we thought, okay. But in any event, it was an interesting insight. So how it rolled. Well, quite frankly, it was no big deal. Once we got through all of that, the reporter sat at the back, and the judge, it's always dealt with as a preliminary issue. The order was made, it was acknowledged, and the restrictions confirmed. And reporter sat at the back. We just cracked on with the normal hearing, forgot she was there. And my client, who had been quite unnerved at the beginning, was completely uninhibited during the hearing, and not in an inappropriate way, but was able to answer questions to the judge and able to engage in proceedings. So, in fact, when you thinking about it in advance, it can be quite angsty. But the reality is, if you have a professional, and the theory is you are only dealing with professionals and they have a vested interest in behaving professionally, it's not a big deal. And so what was the result? Nothing. Story wasn't published. So one wonders whether, and I'll be interested to hear from y'all if you've had journalists coming in since the 27th of January, because I do wonder if there was just a national call to all of the news agencies to send people out to see what was about to test the system, as it were, and then it's just really going to be the cases that are likely to grab national headlines that we're going to be seeing reported, which to a certain extent is not really what was intended. What really was intended was to get an overall understanding of what happens. And yes, in those big cases, you've got to understand the background in all of the hearings to be able to understand the outcome properly. But um, the day-to-day stuff gives you that insight that I would have thought would help in the general reporting of from family court. So what's next? What's to come? So we're still only in the phase of this pilot being rolled out to public law proceedings. It rolls out to private law on the 1st of May this year, and then to family court, to magistrates, lay justices on the 29th of September. So that's Children Act stuff. What happens in the other areas of family law? Well, so far as I can make out, in terms of divorce and dissolution, there hasn't been the same exclusion, save for it is and remains a criminal offense under Section 1 of the Judicial Proceedings Regulation Reports Act to disclose information other than names and addresses. There's a whole list of information that is permissible to report, including the charges, names and addresses and occupation of the parties, submissions, summing up. So a lot more than had been allowed in Children Act proceedings, but that prohibition is in relation to a number of listed cases within the divorce and dissolution sphere, and that remains. So those prohibitions. So in terms of financial remedies, as I mentioned, there is a completely separate pilot undertaken with transparency in financial proceedings, financial remedies proceedings. And the subgroup chair was none other than our own, His Honor Judge Farquhar. And so the rollout for that pilot began on the 29th of January, 2024. And that started at the Central Family Court in Birmingham and Leeds. It was extended in November of that year to the RCJ. And then this year, on the 29th of January, it was rolled out to all of the courts, but it remains a pilot. And so it appears that it's going to be reviewed at the beginning of next year. So what does that relate to? It relates to application for financial remedies on divorce under Schedule 1 of the Children Act and applications under Part 3 of the Matrimonial and Family Proceedings Act. And then, sorry, this is very difficult to read, but as I said, you will all have these slides so you can read them at your leisure. But it relates, so there are what's covered and what's not. All out-of-court settlements should remain confidential and private. And that's just common sense, isn't it? Because there are solid public policy reasons for those conversations to remain private with the view of reaching an agreement. And so it's just common sense that those remain private. And then all cause lists as it contain the names of the parties and identify the subject matter. And there are current provisions about reporting that remain unchanged. And similarly, there's a reporting order to be followed with documents, setting out the documents. The core principle in financial remedies proceedings is that a reporter is permitted to publish information relating to proceedings except the names and addresses of parties, including interveners and their children, and photographs of them. So it's repeating in where there are children involved in financial proceedings, the same provisions apply. In addition, there is other information that is embargoed about employers and property and investments and so forth. And then at the bottom, there is one of the other recommendations from the financial remedies pilot it's basically a repeat of what's been said before. The judges and district judges and circuit judges are encouraged to publish more judgments. And this was something that was um, also raised in the Family and Children Act proceedings and was part of the transparency implementation group. And there was a real push. And you may remember a discussion about it, that judges were really being encouraged, and we were told they were being encouraged to publish more of their judgments. But I think we all might have sympathy with judges and their workload and the time it takes to perfect a judgment in order for it to be published. So whilst there was a drive for more published judgments, which might have assisted in increasing the knowledge and understanding and scrutiny of the family courts, in practice, it is quite difficult to implement. So I think the same is true in financial remedies proceedings. So then, really, that was a very quick canter. I probably spoke at breakneck speed. I apologize for that, but very happily, everything I said is pretty much on paper. So you've got it there, and you will have it there. I've listed some resources for you, and as I said, the technology failed me. Judge Talbot could probably have worked out how to hyperlink his Word document but that's not me. So you'll get it as a separate document, but I've hyperlinked the other information that I thought might be useful for you to have a look at. But I do encourage you, in your spare time, which I know you all have tons of, just to have a quick look through, so that it's not a foreign, scary experience, because quite frankly, it's not. And that's really what I wanted to impart. And that's really why I wanted to do this talk, is to tell you that it's fine. However, having said that and having thought about it, even though there was no reporting in my case, that's something to be vigilant about, because the jury is kind of out on where this goes. And it'll be very interesting to see how this plays out in the end, because whilst the drive is absolutely right that we have scrutiny over what and understanding, both an increase in scrutiny and understanding of what happens in family courts, because it has been shrouded in mystery, which has led to misunderstandings. And we know full well that the reporting is either the local authority have snatched children from loving parents because, they cut their hair in a funny way, or something of that nature, to the local authority. No one has prevented these children from the very serious harm that they have suffered. And there was no middle ground. And so a lot of what the Transparency Project the drive for transparency is trying to demystify that and trying to put some context in the day-to-day of what happens and the decision-making processes that happen, so that you don't get this binary type of reporting. Watch the space, because as we know, particularly those who have practiced in crime, will know that reporters who have been in criminal proceedings throughout do not necessarily report the whole story. And I know from experience that, and you'll be aware, that reporters will sit in court and report the gory detail of the evidence that's being given against a defendant, but not report the fact that he was acquitted, or she, for that matter. And so it's really important to, if you do have a significant case and you do have a journalist attending on a regular basis, and you are conscious that it is being reported. It's something to keep an eye on. Of course, there's no input into editorial um, i- decisions as to how stories are reported, but it is important that the whole story is reported and that facts are reported correctly. So do be vigilant of that in particular. So it will be interesting to see how this plays out and if it actually achieves the objective that it was set out to accomplish. So that's all I have for you this evening. Please, I welcome any experiences that you have that you'd like to share, and I will do my best to answer any questions that you have.